Contracts are the backbone of legal agreements. They define obligations and rights between parties. Understanding how they can be discharged is crucial. A contract is a legally binding promise. It can be written or oral. A valid contract meets all basic elements of contract law. These elements include offer, acceptance, agreement, and consideration. For example, signing to buy a blue house that is indeed blue makes the contract valid. Contracts can end in 4 main ways: by performance when obligations are fulfilled, by agreement when parties decide to terminate, by breach when one party fails to deliver, by frustration when circumstances change materially. Contracts end by performance when obligations are met. Both parties must perform with precision. For fixed-time contracts, performance must be exact by the end date. Any deviation is a breach. The Bolton v. Mahadeva case illustrates this. Partial performance may still warrant payment. It depends on contract terms. Payment is on a quantum meruit basis. It ensures fair remuneration for work done. Acceptance by the other party is crucial. Tendering performance involves attempting to fulfill obligations. If prevented, performance may be considered discharged. Refusal to accept tendered performance can lead to a breach claim. In debtor-creditor scenarios, payment refusal doesn't discharge debt. Payment may be required to be made to the court. Parties can mutually agree to end a contract. This requires fresh consideration to be binding. Variations to terminate are essentially contract changes. A deed can release obligations without consideration. Promissory estoppel may also apply. Contracts may include conditions subsequent. These conditions can terminate obligations. They depend on specific events occurring or not. Control over these events is not necessary. They provide a built-in termination mechanism. Breach termination requires a repudiatory breach. This breach deprives the innocent party of substantial benefits. It's known as the substantially the whole benefit test. Breaches going to the root of the contract qualify. Proper interpretation of breach terms is vital. Anticipatory breach occurs when a party indicates non-performance. It can be explicit or implicit. The innocent party can terminate or sue immediately. They may also affirm the contract. The White v. McGregor case highlights this. Termination rights must be exercised to be effective. Until exercised, contracts remain in force. Notifying the breaching party is essential. Secondary obligations may continue post-termination. Confidentiality and damages obligations persist. Wrongful termination is a repudiatory breach itself. It occurs when termination is attempted without cause. The innocent party can treat the contract as discharged. Damages may be claimed. Proper assessment of breach severity is crucial. Damages are the primary remedy for breach. Injunctions can prevent future breaches. They assume the contract is not terminated. Remedies aim to compensate the innocent party. They address losses incurred. Frustration discharges contracts when performance becomes impossible. Changes must alter obligations fundamentally. The National Carriers v. Panalpina case outlines this. Frustration is not due to inconvenience or increased costs. It's a legal doctrine mitigating absolute contract performance. Frustration can arise in various scenarios. Destruction of the contract's subject matter is one. Death or incapacity of a party can cause it. Supervening illegality or law changes apply. Commercial purpose failure is also a factor. Frustration doesn't apply to mere inconvenience. Increased costs or profit loss don't qualify. Express provisions in contracts can prevent it. Self-induced frustration is not valid. Foreseeable events may exclude its application. Contracts may include cancellation rights. Terms can be express or implied. Automatic renewal clauses might exist. Wrongful termination can lead to breach claims. Proper understanding of terms is essential. COVID-19 has affected contract performance. Factory closures impact supply chains. Just-in-time procurement faces risks. Contract terms may address such disruptions. Legal advice is crucial for affected parties. Contract terms can be conditions, warranties, or innominate terms. Conditions are major terms. Breach allows contract repudiation. Warranties are minor, allowing damages only. Innominate terms depend on the breach's effect. Frustration discharges contracts due to unforeseen events. It alters obligations radically. The doctrine mitigates absolute contract performance. It's an objective test, not subjective. Frustration operates automatically. Frustration discharges future obligations. It doesn't allow contract continuation. Courts can't adjust terms post-frustration. The Law Reform Act addresses payment recovery. Frustration ends contracts automatically. Understanding contract discharge is vital in legal agreements. From performance to frustration, each method has implications. Knowing these helps manage obligations effectively.